Hey everyone, it's Mr. Drake. We're going to continue our look at the Constitution by taking a very cursory glance today at the first 10 amendments of the Constitution, known collectively as the Bill of Rights. We'll talk a little bit about a very brief history of the Bill of Rights and how they came into existence, and then just a quick overview of what each of the first 10 amendments actually says and a little bit about what their ramifications are. First, a very brief overview of the creation of the Bill of Rights. The Constitution became binding when 9 states had ratified it, which happened in early 1789. And the first Congress sat in March of 1789 with 11 of the 13 states taking part. There were still plenty of people out there who opposed the Constitution and this new national government on the grounds that the Constitution, in their view, did not protect people's individual rights. Now, James Madison was one of the authors of the Federalist Papers, and he had argued for a stronger national government, and by virtue of having taken part in writing the Federalist Papers, had sort of opposed a Bill of Rights, but kind of came around to the view that there needed to be some protection of individual liberties in the Constitution, and some loose ends in the Constitution needed to be tied up. So in the summer of 1789, he proposed 20 amendments to the Constitution that he had written. The House of Representatives, of which he was a member, sliced and diced them and ended up paring them down to 17. It then went to the Senate, which did some further hacks and contractions to it, and it ended up being 12 amendments that were sent to the states for ratification. Of those 12, 10 were ratified and became known as the Bill of Rights. You might be wondering, well, what about the other 2? It was actually the First and Second Amendments that were sent to the states that ended up not making the Bill of Rights. The first one had to do with representation in Congress and how many people each representative would actually represent. That one has never made it into the Constitution. The second of the 2 that got hacked said that Congress could not give themselves a pay raise until after the inauguration of the next Congress following the next election. That one was not initially ratified, but was sort of resurrected in the late 20th century, and in 1992 was ratified by enough states to become the 27th Amendment to the Constitution, which makes it the longest period of ratification in the history of the Constitution, 203 years between when it was proposed and when it was ratified. We'll now take a quick look at each of the 10 amendments that comprise the Bill of Rights. We'll be doing a lot more with this in class if you're one of my students, so this is just intended to be a fairly brief overview of each of the 10. The First Amendment is probably the most famous, which protects the rights of the individuals. It says that Congress can't make a law that establishes a state religion or prohibits people from freely exercising religion. That is known as the Establishment Clause. It also says that Congress can't make a law limiting people's freedom of speech or of the press, or the right of people to assemble peacefully, or the right to petition the government for a redress of grievances. In other words, ask government officials to right a wrong or change a policy as people feel the government should. The Second Amendment to the Constitution is probably one of the most controversial, if not the most controversial, not only because gun rights and gun control are a big debate in our country today, but also because the wording of the Second Amendment is a little bit vague. The exact text of the Second Amendment is, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." So some people believe that only applies to members of a state militia, or as we would know it today, the National Guard, and their right to maintain arms for the purpose of doing their duty. Other people have argued over the years that that means that all people can own a firearm, and there shouldn't be limitations on anyone's right to own a gun. The Supreme Court finally weighed in on this issue once and for all in 2008 in the case D.C. versus Heller, and the Supreme Court said that all individuals have the right to own a gun. So according to the Supreme Court of the United States, that is how the Second Amendment is now interpreted, although the debate continues on. We go from the most controversial amendment to probably the least controversial amendment, which is the Third Amendment. It says that citizens cannot be compelled by their government to keep soldiers in their houses during times of peace. This is probably a vestige of the Quartering Act of 1765, which was passed by Parliament in the lead up to the American Revolution, stating that British North American citizens were compelled, if asked, to keep British soldiers in their homes or to otherwise provide for them through providing food or what have you. This amendment is not controversial, and it has never once been the basis of a Supreme Court case. The phrase most commonly associated with the Fourth Amendment is unreasonable searches and seizures, which is a quote directly from the amendment. It essentially requires search warrants to be obtained before someone's property can be searched, and the search warrant has to specifically say what the police or authorities are looking for. This is the basis for what's called the exclusionary rule, where any evidence obtained in a criminal investigation without a warrant or without probable cause to conduct a search in the first place cannot be used. And if you're one of my students, we'll be talking a lot more about that as we discuss civil rights and civil liberties later in this course. The Fifth Amendment most notably says that people cannot be deprived of life, liberty, or property without due process of law. In summary, this amendment deals with rights of the accused. It protects people from self-incrimination, so you cannot be forced to admit to a crime or incriminate yourself in a court proceeding or in any kind of police investigation. It also protects you from what's called double jeopardy. You can't be tried twice for the same crime, even if new evidence comes about after you're acquitted that maybe proves that you're guilty. This amendment is the basis for what we call the Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in a court of law. This amendment was the centerpiece of the case of Miranda versus Arizona in 1966, which dictated that all people accused of a crime had to be notified of their rights. This amendment also ensures that you will be compensated if your land is seized by the government for public use under the principle of eminent domain. If your house is in the way of a freeway that needs to be constructed, the government does have the right to take your house and condemn it and force you to move, but you have to be paid for whatever property they seize from you. Amendments 6 and 7 both deal with trial by jury. The Sixth Amendment pertains to criminal proceedings and says that if you are the defendant in a criminal trial, you have the right to counsel or an attorney, even if you can't afford it. The Supreme Court case of Gideon versus Wainwright in 1963 said that even if you can't afford an attorney, the courts have to provide one for you. You have to be notified of what you're being charged with. You have the right to an impartial jury of your peers, and you have the right to confront any witnesses who are testifying against you. That means essentially that if someone testifies that you did something, you have the right to cross-examine them. That's what we mean by confront. You don't mean you actually physically have an altercation with them or anything like that. The Seventh Amendment says that you have the right to a jury trial in a civil proceeding if the amount in dispute exceeds $20. So if there is some kind of, negligent suit or someone owes you money and they're not paying up, if it's a federal case and the amount exceeds $20, you have the right to a civil trial where a jury will sort of arbitrate the decision. The Eighth Amendment is most famous for the phrase cruel and unusual punishment. Usually this amendment is applied to issues regarding the death penalty. The death penalty was declared unconstitutional for a time in the United States because of the way it was applied and what crimes it was applied to and things like that. And that was fairly recently. That was in the 1960s and 70s. Some examples of where this was applied: death penalty for rape has been deemed cruel and unusual. You cannot condemn to death someone who committed a murder when they were a minor. It also protects minors from life imprisonment without the possibility of parole. The Eighth Amendment also protects against excessive bail amounts or excessive fines, but it doesn't define what excessive means, so it's open to interpretation by courts and judges. Finally, the Ninth and Tenth Amendments, which sort of tie up some loose ends. The Ninth Amendment says that a person's rights are not limited to the ones that are specifically listed in the Constitution or in the Bill of Rights. So just because it's not in the Constitution doesn't mean you don't have that right, in other words. Most notably, this amendment has been used to infer a right to privacy that people have. And the basis of Roe versus Wade, the Supreme Court case that said that women could not be denied an abortion in the first trimester of pregnancy, that was decided based on the Ninth Amendment right to privacy that women have. Also, cases where the availability of birth control was in dispute, right to privacy was applied. The 10th Amendment says that powers that are not specifically given by the Constitution to the federal government and powers that are not specifically denied to the states are rights or powers that the states have. These are called reserved powers. Some examples of reserved powers might be the right to regulate state education, or the right to determine laws regarding marriage would be a very pertinent current example given the debate over gay marriage. The Constitution says nothing about marriage laws and doesn't say that the states can't regulate marriage laws, so that's a power that the states have, which is why some states allow gay marriage while others don't have to. That will do it for our look at the Bill of Rights. As always, make sure you're looking over your notes, and as always, be sure to ask me if you have any questions. Cheers!